Dan Saval, welcome to the DCQ podcast special sits. I'm very happy to have you on. I'm very grateful also that you could accommodate doing this in the weekend. How are you and from where are you joining us today?
Yeah. So, first of all, thank you, Peter, for inviting me to this podcast. It's a pleasure to speak with you, as always, but particularly in this setting. Today, I am in my home in Connecticut, in the suburbs of New York City. So, looking forward to talking with you about all things restructuring, special situations, and anything else that you or those who are listening to your podcast may find of interest.
Excellent. Well, look, I'm still on location in Leiden, the Netherlands. I've started there an interim job in May, and I have to say, very interesting, very full on. But today, maybe just give the listeners some background. You are a U.S. Lawyer working out of New York and in the special sit space. And maybe we can start with, are you born and bred New Yorker or did you grow up somewhere else in the States?
Yeah, so I am not a born and bred New Yorker. I think over time I've grown to consider myself a New Yorker, but I am originally from the suburbs of Boston and had a great upbringing in those suburbs. I grew up in a town called Stoughton. Um, I still keep in touch with my very good friends from high school. We're actually on a text chat and speak almost daily.
Wow.
So shows you the bonds that I formed very early in life. And what's funny is that while New York is in very close physical proximity to Boston, when I was growing up, New York seemed to be a world away. And on top of that, um, so my dad instilled in me the sense that if you were going to be loyal to Boston, you would never move to New York because it was the evil empire of sports teams, and particularly the New York Yankees
Yeah.
were arch rivals. And growing up, there was this stereotype that New York was this place that was uh, oppressive and dirty, and the people were obnoxious. And I think many who still live in that area still have that view about New York. And it was interesting because when I moved to New York in 2005, all of my preconceptions about what New York is or could be were absolutely shattered. And I fell in love with the city. It, it's
Wow.
just it's just an incredible place. And New York has really had a profound influence on me, both professionally and personally. And so I feel like the decision to move to New York in 2005, after I had been practicing for a few years at Brown Rudnick, where I started in their Boston office, I felt that that was one of the best decisions I've ever made in my life.
For me too, New York is special in many ways. It's I did a 1 year LLM there. I met my wife there. Our first son was born there. It's been the headquarters of, a number of law firms that I've, been part of. And it is very special. It has a special buzz. It has a special energy and a special, place in my heart. Have
Yeah.
to say, London has probably, stolen my heart completely. And I feel probably more of a Londoner now than a New Yorker. But it could have been, the reverse if
Yeah.
things had gone a different way. So your friends from Boston, now that you have confessed you're actually a New Yorker, do they accept that or have they looked at you differently ever since you made that decision to, become part of the enemy?
I think it's a mix. I try and at least play off that I am still a local guy, um, and that I still follow the local sports teams. It's really interesting because I get a lot of scuttlebutt about what's happening around town from my friends. And so I'll often speak with my parents who are still there and tell them things they didn't know about what was going on.
Excellent.
um, so,
So, and are your parents maybe just zooming in on um, when did you make the decision to pursue a career in law, and how did that career in law got you to the special sit space? Are you part of like a family of many lawyers and sort of you are destined to become the next lawyer, or was it a path that you've created for yourself and you're sort of trailblazing a little bit in a space that your family doesn't have any experience with?
yeah, I'm glad you asked that question because when I think back to where I started as a kid and then going through college and law school and onward, ultimately into the field of cross border insolvency, I certainly had no intentions. And frankly, I didn't even think I had a desire to be a lawyer. Um, I do think my father was very influential in my decision to ultimately pursue a career in law. He's not a lawyer, but he was a high school teacher for many years. And he actually studied international relations.
Okay.
And he taught a course which was really one of its kind at the high school level on constitutional law. So growing up, I was socialized to issues of law, not in the deeply technical sense that is involved in day to day practice of a lawyer, but it was something that I was exposed to and I thought was interesting. And um, in high school, I tended to do well in math and science. And at the time, there was this view that if you were good at math and science, you went into engineering. That was really um, sort of a ideal profession. There were a lot of jobs, a lot of opportunities. You could have a stable career, make good money. And so I kind of just went with that. And so when I entered university and I went to the University of Pennsylvania, Philadelphia, I started in that field, but became very apparent to me that that's not something I really wanted to do. I like math, I like science, but once I got into this lab course where I was having to figure out how all these wires were being connected and like to do what electrical engineers did, I said, this is just not for me. And
Mm.
so I changed my major or area of focus to intellectual history, which is essentially the study of thought and philosophy within its historical context. And I,
That's a great foundation, isn't it? I mean, for anything in life, I would think.
yeah, I really enjoyed the classes I took. The professors I had It really opened my mind, my way of thinking, and I like that it wasn't pure philosophy because we were trying to understand how the times were influencing the way people were thinking, and I think that aspect of my education proved valuable or invaluable to what I do professionally, and just understanding the evolution of how people, for example, think about restructuring and special situations and otherwise. Um,
Yep.
but even then, after I had become an intellectual history major, I still was not thinking about becoming a lawyer. I didn't really know what I wanted to do. And so I graduated. I spent some time in California, in San Francisco, Los Angeles. I have a cousin in San Fran. My sister lives in LA. I was like sleeping on her couch, working at a bookstore. Um,
So that was a gap year for you, or was that
yeah,
sort of
it
figuring
was.
out after college?
I was figuring out what I was gonna do. I had this bug in me about music. I had always enjoyed music, played music. I'd been in bands in high school and college. thought maybe that was something I wanted to pursue. I'd call it more of a
And what's the
fantasy.
instrument that you're playing?
So,
Is it?
um, yeah, I started playing guitar, and I still play the guitar. And I play it a lot. Actually, it's a really great outlet. But in college, um, when I wanted to join a particular band, they already had two guitarists, and so I decided that I would learn to play the bass guitar, which is an instrument I love. I don't get to play it as much now because I'm not in a band, but it is a really cool instrument. And um, actually, thinking about this podcast, I've realized my experiences playing music have had some learnings for me professionally, because when you're in a band and you're playing with others, there's a need to be in sync and connected with those that you're playing with.
Mm,
And that is something that, is really key to, I think, successfully practicing in any area, or whether it's law or not law, being able to function as a team. And so I looked fondly at, the times that I had, doing that. But in terms of the career progression, it became clear to me that was not going to be in the cards. I wasn't going to be a rock star. And so my sister eventually said, like, you can't live here anymore. You need to go back home to Boston. And I said, okay, what am I going to do? And my best friends from high school had already either entered law school or going to law school the following year. And I said, you know what? I really like them. I respect them. I'm going to follow suit. It sounds like something that, would suit my interests. Although I had a lot of people tell me, be wary of going to law school.
mm.
Lawyers are miserable. They lead lives that are incredibly stressful, incredibly demanding. But I think,
And did
thankfully,
you know any lawyers, or no lawyers? That was
I
just
didn't,
the
I didn't,
rumors, the sort of stories that you heard. But
yeah, I didn't know any lawyers well. I knew of lawyers, but I didn't know actually what the day-to-day practice really looked until
right.
I got in the thick of it, and went to law school and started to do internships with law firms, and ultimately became a summer associate at Brown Rudnick,
Oh
um,
wow.
in, in their Boston office in 2001. And I know that you know a fair bit about Brown Rudnick because,
Well, yeah, around that time, yeah, exactly. That was just before I joined. I
yeah,
joined them in 2002, and yeah, that's sort of where we met. And Brown Rudnick, yeah, in itself is an absolute fascinating firm, Boston based for sure. So
yeah. So
no surprise that you started there.
yeah, so it was actually interesting because I went to law school, decided, you know what, I actually like this and I want to do it. I want to join a firm. But I decided I was going to practice in Boston. That's where I was based. That's where my family was. That's where my friends were. Um, Again, I had no intention, or the thought never occurred to me that I'd be in New York. And at the time when I was a summer associate at Brown Rudnick, there wasn't even a New York office. It was a New England based firm, and it had a London office, um, and it had a DC office, I believe. But the practice was nothing like the way it evolved, particularly in the bankruptcy and restructuring space. And I thought I wanted to do general commercial litigation. And why I wanted to do that, and particularly at Brown Rudnick, was that at the time I was a summer associate, the firm was doing some real cutting edge litigation, suing the tobacco companies on behalf
Mm.
of Massachusetts and several other New England states, at a time where the tobacco companies had never paid a dime to resolve or settle any cases. So it was a very risky case for the firm. the firm got a lot of publicity, particularly in the local media, the Boston Globe, and other publications. And so I thought it was a really exciting place to be. And that was the type of work I thought I wanted to do. Um, Lo and behold, um, when I came back to the firm, now this was after a clerkship, a judicial clerkship working for a judge at the Massachusetts Appeals Court. When I, rejoined the firm, it had merged with a New York boutique called Burlak, Israels and Lieberman that had as its premier practice bankruptcy. And the practice was led by, as you know, Ed Weisfellner.
Yep.
And he brought to the firm um, clients and a reputation to handle these really big creditor committee cases. And the firm was just swimming in work from the work that Ed drew in. And at the time that I rejoined the firm as an associate, it was the dot-com bust, or following the dot-com bust of the early 2000s. MCI WorldCom, Global Crossing, they all collapsed. And the firm was just swimming in bankruptcy work. And so what they did was everyone that was going to do litigation was basically moved over to the bankruptcy. And
Wow.
I was very disappointed about that, because I didn't know anything about bankruptcy. I'll admit that. I
So
wasn't.
nothing in law school you had on bankruptcy, or very little. There weren't much sort of courses on it.
Yeah, so I didn't take bankruptcy. I didn't know I was going to do it. I had a view of the practice that it was dry and it's boring. And of course, now I think it's the most fascinating area of law ever. And we'll obviously get to that.
Yeah.
Sort of what's inspired me to have those feelings and that perspective. But at the time, what I thought bankruptcy about was just like foreclosures, or taking assets, and nothing really interesting.
Liquidations, basically, right? Just
Yeah,
cleaning up.
and I think the practice at Brown Rudnick before it merged with Burlak Israels Lieberman was a bank heavy practice,
Okay.
representing the regional banks in the New England area, doing the deals. And actually, there wasn't even a bankruptcy group. It was called Banking and Finance, because the predominant clients were the regional banks that would hire the firm to do the financings, and then ultimately do the workouts. And then ultimately, when things really deteriorated, to do the bankruptcy proceedings. So it was like this cradle to grave practice.
Yeah.
And so, again, I didn't think I wanted to do bankruptcy, didn't take it in law school. Although when I look back, there were courses I took in law school that, without knowing it, I think really helped me with what I do today in the field of cross-border insolvency, such as courses in international law, conflicts of law, which is a big issue in almost every cross-border insolvency and restructuring case. And I took a course on federal courts, which I loved. Federal courts is the study of the division of power between the U.S. federal courts and the U.S. state courts. And, sure you know this, Peter, that U.S. bankruptcy law is U.S. federal law, and it's those laws are, you know, applied in the federal courts, specifically the U.S. bankruptcy courts that are federal courts. And in a bankruptcy proceeding, there are constantly issues about whether issues should be decided under state law or U.S. federal law. And that's one of the things I find fascinating about bankruptcy law, is the interplay between federal bankruptcy law and, for example, state property law, because obviously property rights are pretty significant and they need to be incorporated into the bankruptcy regime, but it's a delicate balance. But sort of going back to what we were sort of focused on, I, joined the firm or rejoined the firm as an associate in um, 2003.
And so just before you joined, you had a clerkship, and not all jurisdictions have clerkships, preceding going into private practice. But in the
Yeah.
US, it's something that people try to do. What does a clerkship actually, you know, add, and how does it prepare you for, I guess, private practice subsequently? Is it something that, you would endorse, or is it something that is just a US feature and everybody does it? How was that for you?
Yeah. So the clerkship I had was just an amazing experience. In large part due to the judge that I clerked for. Her name was Barbara Lenk. She sat on the Massachusetts Appeals Court and actually was a Brown Rudnick alumni.
Oh,
Her
wow.
practice was in First Amendment freedom of speech law. And I actually had the option of just going and working at Brown Rudnick, making a lot more money right out of law school. But I decided that it would be worth it to have that experience, and to have a year where I was seeing how the sausage got made. And it was such an incredible experience on many levels. Substantively, I learned how to write, and uh, my judge was uh, someone that I would say exhibited tough love. She was very demanding and expected a lot out of her clerks. Um, she had this tradition, so to speak, for the incoming clerks. You would get a letter in the mail telling you that by the first day that you reported to court, you were to have reviewed 4 cases that were going to be heard in the next term and have bench memos prepared. And you were to submit them on your first day of showing up.
Wow.
And that was my introduction to this judge. And I remember going in on the first day really stressed out. I hadn't finished my memos. All the other clerks were, casually walking in, having lunches with their judges. And there I am furiously like trying to, complete these 4 bench memos. But there was a rhyme and a reason for that. And that was just to get me and to get her clerks in the habit of, you know, writing and analyzing and reading. And while I just said that, the judge was exhibiting tough love, she was such a compassionate woman. And she actually passed away recently. So she's very front of mind for me. And separate from the substantive learnings from the judge, being just in her chambers constantly for that year and talking about cases, hearing about her experiences, getting the benefit of her wisdom was just something that was just invaluable and something I never would have gotten in another setting.
Right.
And
But she
so
was not a bankruptcy judge, right?
she
So,
was
so
not, yeah, she was not a bankruptcy judge. She, at the appeals court, we handled a mix of civil and criminal cases. But undoubtedly, that experience helped me, to become a better lawyer with
yep.
the perspective and the substantive skills that I gained. And I knew, even when I was doing that clerkship, that I was going to go and join a firm that would put me in the bankruptcy group. But I still thought it would be worth doing because, in my mind, I'd sort of do my service in bankruptcy, and then I'd convince
And then
people,
go back to
and then go
what
back
you
to,
wanted to do.
yeah. So there I was, and
But so that's actually very interesting because again, the states and bankruptcy in the states is very much court driven, right? And actually, the judge has a very important role. I mean, sure, judges in the UK have a role to play as well, but nothing as, dominant as, the US judge in a bankruptcy case. So maybe, unbeknownst to you then, having had, the insight of looking at how a judge handles the court, what goes on behind the scenes, sort of helps in the bankruptcy setting as well, where you also need to deal with a judge, and the judge actually has a pivotal role to play. And knowing a little bit on the other side, how things are going, that must have set you up well to understand things that maybe others that didn't do a clerkship would have troubles actually, understanding.
Yeah, absolutely. Because the way I see it is that whenever you're in a contentious situation that needs to be resolved by a judge, there's one person that matters, only one person, it's the judge. And I think many litigators, and I've, fallen into this trap a few times, they think that their job is to beat up on the other side, to whatever the other side says, you need to show why they're wrong. When in fact, your job is to educate and persuade that one person, the judge, to rule for you. And so it's over time, I realized how important it is to get a read of the judge, to form a rapport with the judge, to try and develop a relationship with the judge, to see what makes judges tick and what resonates with them, what doesn't resonate with them. And that's not something that you necessarily get by just reading their opinions or by knowing the law or having the best arguments.
And I think especially in the special sit space, and probably we'll get to that, but ultimately, polarizing things, which, is the essence of litigation, you're adversarial on both sides, is not necessarily the way to, be successful in the special sit space. In the special sit space, you need to have, obviously, the ability to, argue stuff, but you also need to have the ability to bridge differences and, come to, I guess, common ground so you can get a deal done. And that's sort of, something that maybe, especially in our space, which is litigious, which is court driven, which deals with a judge, but it's an ability that you also need to obtain. Because if you're pure litigator, I think you're probably missing a trick. If you're pure transactional, you're probably missing a trick
Yeah.
as well. It's the combination of the two that is so important in our space.
Yes. And it's relationships is in large part what drives our world of restructuring special situations. Relationships with your clients, the investors who may be on your side or may be adverse to you, the other professionals and the judge. And
Yeah.
it's important to develop good relationships with all of them and to have them sort of trust you and feel that you are credible and you're someone that they can believe. So reputation is incredibly important in our world.
So, and that is actually interesting because what was the reputation of, the bankruptcy group of Brown Rudnick? Obviously, it
Yeah.
was almost a personification of the head of the group, Ed Weisfellner. And Ed
Yeah.
Weisfellner, an incredible person with a great mind, but also, a lot of courage. And he wasn't afraid to sort of throw some bombs and be in the trenches if that was necessary. So is that something that also fits with you when you sort of started new and decided, maybe New York is the place for me to go? But that is sort of the environment you get into.
Yeah, so that's actually a good segue to how I got to the point where I decided to move to New York, where I decided I loved bankruptcy, and frankly, where I decided I wanted to work with Ed. Um,
Yep.
I had been at the firm for a little bit and frankly did not find the work particularly interesting or engaging, or the work I was doing in Boston. But then I was staffed on this case called Mirren. Mirren was a merchant power company and filed Chapter 11 in Texas. And at the time, it was, I believe, one of the largest bankruptcies in history. And the firm represented the official committee of shareholders. And so, as you know, when shareholders are involved in a case and they're trying to realize a recovery, it's almost always an uphill battle. And those were precisely the types of cases that, Ed Weisfellner in the firm was known for being really scrappy, but being really savvy as well, and knowing how to apply pressure in the right places.
Yeah,
And,
fighting for the underdog.
yeah, fighting for the underdog. And the case presented this absolute David versus Goliath dynamic where the debtors and the creditors committees, there were actually two of them. So there were three parties that all took the position that the shareholders were not only out of the money, but there was a $2 billion US gap between what they said the company was worth and what it would take to get the shareholders a recovery. Somehow, and I don't remember the exact details of this, but Ed was able to engineer the case to persuade the judge to hold a separate valuation trial. So typically in a US bankruptcy case, issues of valuation and who gets what under a plan are decided within the context of a plan confirmation hearing. This judge, Judge Lynn, decided that he would decide the issue of value separately. And so I got involved in this case and was the junior member of the trial team. And this is regarded as one of the most well-known, some people say epic valuation fights in history, because the trial went on for 27 days and involved, I think, maybe 6 or more valuation experts. And it was incredibly contentious, but also incredibly exciting, dynamic. I love the fact that we were fighting for the underdog. And the clients, those who sat on the equity committee, they were not distressed debt investors. They were retail holders or representatives of the retail holders, many of which had put their retirement savings into Mirren. And so I felt also that we were fighting the good fight. And at the end of that trial, the judge issued a decision that forced the company to redo its projections and its valuation. And as a result, it led to a settlement where the equity holders or the shareholders got recoveries that were ultimately valued in excess of $1 billion. So to see that—
That's amazing. Because, getting, the value to break, well, having the equity get something is a tall order in many distress situations. But that's a great result.
Yeah, so it was just like the juices were flowing as a result of that experience, and I really loved seeing Ed in action. And there were others in the New York office that I also found that I had a connection with. And so there was only one other bankruptcy associate in the New York office at the time. And the practice group leader, Bill Baldiga, floated that if anyone was interested in going down to the New York office, it would be supported. And so I raised my hand and said, hey, I think this is something I want to try out. Now, at the time, I thought maybe I'd spend a couple years there and then go back to Boston. But you know what happens, Peter. You move somewhere and then 20 years later, you're, still in the same place. And so, that's was really the story of me coming to New York and um, at the same time learning to really love the practice of high stakes restructurings and bankruptcy.
Yeah. And so what was then the big difference for you between, Boston and New York? I guess in the special sit space, a lot more filings in New York, a lot more, I guess, clients or stakeholders in New York as opposed to Boston. And obviously, yeah, if you're doing things for the banks are a player. Historically, we're a big player, but things have changed as well, right? So, what was sort of your experience there? Because when you started, and then sort of see the development where we are now, the bank's role has changed,
Yeah.
and new players have come up. The bondholders have come up. That was also a part of the practice that was big in New York. How did you get involved in that?
Yeah. So it's a great question. And what was really amazing when I moved to New York was the level of face to face interaction I had with the clients that worked at hedge funds. A lot of the cases that we were doing involved representing ad hoc committees of bondholders, sometimes equity holders, sometimes bank debt holders. And within these groups, there were often a dozen or more of financial institutions or hedge funds. And there's no way that Ed or any of the other senior partners would have been able to field all the calls and meet all the clients and answer their questions that they constantly had about what was going on in the case, what the strategy was. And so when I moved to New York, I was on the phone all the time with these folks at hedge funds, these analysts, just asking me, a lot of questions about, the strategy and how I saw certain legal issues playing out. And I was kind of thrown into the fire a bit because no one taught me how to talk to a client. That was something
I
I, I
I
just,
I, I, I can resonate with that so much because when I sort of decided to leave the Netherlands behind and move to a US law firm, which I did, first at Aiken Gum. Robert Stark, Bob Stark was there as well. So, I was next door from him. And he sort of, was instrumental for me getting to Brown Rutnick subsequently. But exactly what you're sort of describing sort of happened to me. I was already, 7.5 years in, but had never spoken with, a hedge fund before. So
yeah,
I was in New York to start with for, 7, 8 months before I went to London. And exactly what you're describing. All these funds calling with all these questions and very sophisticated, very smart, very quick thinking, and yeah, nobody tells you actually how to deal with
yeah,
these people. But you learn a lot, and if you do a lot of these calls, yeah, you steep learning curve, but very interesting, and it develops you quick.
yeah. Absolutely. And I certainly made my share of mistakes, or I'm sure I said a lot of things that would be considered wrong in hindsight. But, you know, I'm a big believer in you learn by doing and you learn from your mistakes. And that, was the opportunity for me to have that experience. And, you know,
And do you think, because we were sort of talking about it earlier, the reputation that bankruptcy historically has, right? It's sort of, you want to stay away from it. It's no glamour. It's all, cleaning up stuff. It's maybe working out loans for a bank.
yeah,
But with sophisticated professional players like hedge funds coming in and a secondary market in distressed debt being developed in the US. And, the US is sort of leading in the world on those two things, hedge funds and the distressed debt market. things change, right? Because all of a sudden you're not dealing with people that are inadvertently stuck in a financially distressed situation. No, these are people that seek out these
Yeah.
situations to actually, make a contribution to obviously make money, but also to try to, restructure things as opposed to only liquidate things. And they bring something to the game to do that. And to me, that changes everything, right? Because the whole mentality changes. And obviously, if you can buy into a situation at a distressed level, i.e., at a discount, then, to have a successful investment is completely different from, the par holder who is down in the hole and, will minimize the loss, right? Those two things are completely different, and it changes the dynamic of the whole case.
Yeah, absolutely. And what's remarkable, because I've now had the experience of doing a lot of work on both the debtor side, those who are, have built up businesses that they have to put into insolvency or restructuring, and then on the other side, the sophisticated investors, and it's apples and oranges. It's a lot less emotion on the hedge fund side. It's when you're speaking with these folks, they have their Excel models. They're trying to figure out, what is the likelihood of recovering at different levels. They're asking you questions to input into their models so that they can assess probabilities of success at different, under different scenarios. Um, it, and as I said before, they're incredibly smart, incredibly sophisticated. Um, uh, but they obviously are not folks that have lived and breathed the business like the folks on the debtor side have. So
Yeah.
it's really interesting contrast in having represented folks on both sides.
So is it then a cookies again? It's also to sort of take the taboo away from quote unquote failure, right? Shame, everything relating to this financial distress is
Yeah.
a lot of it is denial, ever denying that there's an issue until it's way too late. Because, yeah, you feel like it's something I can't talk about. Uh, those are tensions that are an integral part of financial distress. And obviously, at the debtor side, you will firsthand see those if you're advising, that side. I also firsthand see it if you're, coming in an interim role and you be part of it, exactly the same thing. But the sophisticated creditors or investors on the outside, yeah, if they lack any sort of sense of what the tensions and the stress is there, there can be a mismatch as well. It's great that they are a lot more creative in finding solutions, but solutions is not everything, right? It's
Yeah.
also understanding the pressures and acting accordingly, right? Because we're still dealing with human beings. And ultimately, getting a deal done is not only the numbers, but it's also, I guess, the human touch that you need, right? Which is what
Yeah.
you earlier said.
Absolutely. And the psychology and the motivations behind the various players is so important. And something that I think you really need to live to fully understand and to have that knowledge and insights, because in any of these situations, um, you don't have the luxury of years and years of figuring stuff out. There's a pressure cooker of a situation. Money's running out. The lender is putting, all sorts of controls over how their dip money is going to be used. So solutions have to be worked out amongst people who are coming from completely different perspectives and have completely different interests. Are in their characters are just so different, and sort of navigating that is something that is both challenging but also makes the practice incredibly compelling and interesting, and it never gets old.
No, no. And so going back to New York and Ed's team and sort of, taking the cases that are the hard cases,
Yeah.
the reputation of fighters. You were saying earlier, reputation is everything, right? So how do you then sort of, if you're part of that reputation, are you then stuck dealing with creditor cases, and therefore there is no opportunity to do debtor work?
Yeah. So that's a really good question. One I've thought about a lot, because when I think about my personality, my strengths, what I'm interested in, and how I feel I can best approach cases, I am not the model of Ed, or someone who comes in a super hyper aggressive way. That's not to say that um, you know that type of persona doesn't have benefits, particularly in the cases where you're representing um, constituents at the junior levels of the capital structure. But I think you're right that it's limiting, that when that is your reputation, um, then you're obviously seeing certain cases and you're not seeing other cases.
Mm.
Um, I did have some exposure to debtor work along the way, but not a lot. Um, and this may be a good segue to sort of the next sort of phase of my career, which um, leads to my involvement in cross-border restructuring and insolvency. And that was in 2005, when the US Congress adopted Chapter 15, which was based on the UNCITRAL model law and cross-border insolvency. So that was a few years into me being in New York. And um, we didn't have any international cases at the time, but that was something I thought I should learn. And there was a lot of buzz about it. And I said, this is really cool that this happened, because I had an academic and intellectual interest in international law and international issues. And so wouldn't it be great to try and do stuff in this world? Um, and then um, a few years later, you had the financial crisis
Yeah.
of 2008, which was a game changer for everyone in this business, um, and created tremendous opportunities for a lot of folks in different ways um, that do restructuring. For me, the thing that happened was we ended up representing the liquidators of Fairfield Century. Fairfield Century was the largest of the feeder firms to Bernie Madoff. And as you know, and as everyone knows, um, at the time of the financial crisis, when the markets collapsed, the Madoff fraud was exposed. And that set in motion lots and lots of bankruptcy proceedings, both in the US, abroad, liquidations everywhere, in Europe, in the offshore jurisdictions. But um, it was really that case, representing the liquidators of Fairfield Century, which was a British Virgin Islands fund, that really pushed me in this new direction of cross-border uh, insolvency, using insolvency tools for asset recovery, um, and just this world and that I live in now, that has me dealing with folks in different jurisdictions almost every day, both internally at the firm and externally.
So, but that is on the back of fraud, right? And again, go to reputation of the special sit space and bankruptcy. For the man and woman in the street, it usually is an association with fraud, right?
Yeah.
With failure and fraud. And we all know that there's many reasons for financial distress. And it's a normal part of the I guess, the cycle of life of companies, right? At times, you will just face financial distress that doesn't need to be terminal. It can be something that you can deal with, but you need to deal with it, I guess, in time. And that's sometimes difficult. Fraud, different story, right? Madoff have continued, and how long would he have continued if the financial crisis didn't hit? Very sophisticated, fraud, and a lot of people that fell for it that were very sophisticated as well.
Yeah.
Is that now a big part of what you do? Have you sort of transitioned from, I guess, insolvency for other reasons to insolvency for fraud reasons primarily?
Yeah. So, what's interesting about my practice today, is that it's a mix of the uh, cross-border insolvency that's used as a tool where is fraud, there's a collapse of a fund or a company, and there's a campaign to pursue assets or to go after people, to bring claims, proprietary claims to recover stolen money, or non-proprietary claims where you're holding someone accountable for the damage that they've done to a business. So that's sort of on the one side. And then there's this other lane that I continue to practice in restructuring. Um, and that was something that I didn't, when I joined Kobre Kim in 2017, I thought I'd be doing a lot more of the former. And I do a lot of that work that's really at the core of what the firm does: international disputes, litigation, investigations. Um, but when I joined Kobre Kim and got situated, um, it became clear that there were opportunities in the general restructuring market that were untapped. Um,
Right.
because the firm, as you may know, and just for the listeners, is unique in that while it's a global firm, we only do disputes in investigations. We don't have a transactional practice. And therefore, in most situations, not only are we conflict free, but we are independent, in the sense that we don't have long-standing client relationships that would inhibit us from taking positions in cases. We're calling it the way we see it. And so, um, one of the first cases I worked on when I joined uh, Kobre Kim related to the bankruptcy of Puerto Rico. As you may know, Congress set up a special bankruptcy regime for Puerto Rico due to its overwhelming financial distress. And it was this new legislation largely modeled on the bankruptcy code and incorporating provisions of the bankruptcy code. But the role that our firm had was to serve as the independent investigator, to report to the Financial Oversight and Management Board, basically the government uh, board of directors for Puerto Rico. And we were charged, within the span of about a year, to do a deep dive into the causes of the financial crisis in Puerto Rico, report on them, and make assessments about whether there may be claims and causes of action that could be pursued.
And did you have special powers to do so? Or did you have to use the existing powers, in the code and elsewhere?
Yeah, so we approached that case with a mix of uh, requests for voluntary interviews, but also we did have subpoena power, um, just as a trustee would have in a bankruptcy case.
Right. Because, yeah, obviously people are not going to volunteer necessarily to tell you how they dropped the ball here and how they dropped the ball there, right?
Yeah, yeah. Interestingly, though, most of those that we wanted to talk to agreed to talk to us. And
Okay.
that is, something that I think comes with the art of developing an investigations practice, is persuading people that it's better off to talk to you outside of a court process than to compel you to talk to you, like in a deposition or under oath. Um, and so it was through that experience and with the firm wanting to build up a bankruptcy team. And I was part of that sort of build up, that we learned early on that there were these opportunities, particularly on the debtor side, to represent special board committees, um, you know, committees formed of people like yourself that are restructuring professionals and come in who have no existing tie to the business. They have the experience to navigate a restructuring, and they're not affiliated, for example, with a private equity fund that may have, seats on the board or even a majority of the board interest. And
Yep.
around this time, this was 2018, 2019, I think there was a recognition within the market that to run a successful restructuring, um, not only did you need to appoint independent directors, where, for example, you had a private equity fund running the business and having control over the board, but that there should be an independent law firm that would come in, and that shouldn't necessarily be, the Kirkland and Ellis or the Latham and Watkins that are general restructuring counsel doing the work to, for example, investigate whether there are claims and causes of action that should be pursued, or whether claims and causes of action should be released under a plan. And so that has become a significant aspect of my practice. I really enjoy that I still get to work very closely and deeply within the restructuring space, in that capacity, and work with a lot of talented professionals. But I also love the fact that, I can pivot and be in this other world that's closer to the Madoff type stuff where there's fraud and there are offshore liquidations, and you're representing liquidators and mapping out where you can file recognition proceedings to get powers under local insolvency law to get information or to bring claims or to pursue assets. I think the variety between the two worlds is something that, really keeps me going and makes my job, really exciting, and has given me the opportunity to work on some really fascinating stuff over the years.
So if we zoom in on, I guess, the type of law firm that Kobre Kim is, and if you compare it to, for example, a Brown Rudnick or any other law firm, really is ultimately it is trying to get credit for getting work in and doing work right. And the hope and expectation is that you can indeed have repeat business. But if you're set up differently and you cannot have repeat business, you actually need to actively disconnect with clients so that you're free,
Yeah.
and you can take on new things without conflict. But you're no longer a boutique firm, because obviously initially
Yeah.
Kobre Kim was relatively small, but it isn't at the moment, right? I think it's like 400 or 500 people. It covers the globe.
Yeah.
How does that then work, compared to the traditional law firm? Is there anything that you can sort of say about that? Because that is, in my mind, fairly unique.
Yeah, no, that's a great question. And the firm is certainly set up in a unique way, in a number of different respects, all by design. Um, you're right that it is difficult to call the firm a boutique still, given the number of offices we have. I think we're up to 14 or maybe 15. But overall, we're not a large firm by headcount. We have about 150 lawyers spread out amongst all of those offices. Now, in addition to that, we have several dozen analysts. Those are non-lawyers, typically university graduates that support the cases in different ways. For example, for the investigations work, the analysts will do a lot of the fact gathering, the intelligence gathering, and the like. But even with the combined headcount, we are still a pretty small firm. And that design, I think, allows us to capture and execute and win cases that require coordinated activity amongst jurisdictions. And what I mean by that is that many firms have a global footprint and have offices all over the place. But that doesn't necessarily mean that the lawyers from the different offices are working together or necessarily even like know the lawyers in the different offices.
That's oftentimes the challenge, right? That you have
Yeah,
like, all kinds of islands and people just indeed running their own practice alongside other practices, but not coordinated throughout the
yeah,
firm.
yeah. And so at Kobre and Kim, um, both both I and pretty much everyone who works there is constantly working with the others, whether lawyers or analysts or other professionals in the other jurisdictions. I mean, um, I was on a call yesterday for a new matter with one of my colleagues from Hong Kong, with one of my colleagues from Dubai, from Sao Paulo, London, um, and also with a colleague from our Shanghai office. And
Wow.
a lot of what we do is sort of mapping out, for clients that have global problems, where should they take action? And rather than hiring lawyers in different jurisdictions just to do something specific in their jurisdiction, our approach is let's look at the globe almost as like a chessboard with the different jurisdictions having potentially significant role to play in recovering assets or applying pressure. But considering that if we do something in one jurisdiction, would that have a negative effect in some other jurisdiction? And we're constantly thinking about, well, what is the best jurisdiction to file a particular, proceeding in, or seek a freezing order, or pursue discovery or a cross-border recognition proceeding? And that's really at the DNA of Kobre and Kim. And I think to effectively operate in that environment, um, you need to have a group of lawyers that is committed to working together as a team. You really can't have lawyers that are all about themselves or, have their own books of business. And they say, I'm only going to do my work and, I'll only help you if, I get some like benefit that's articulated. That's really not the way our firm works.
So how are you credited then? If that is not the way that you're credited,
Yeah.
is it just how much of a team player you are, what the work is that you do on a case?
Yeah, so that's a great question. What I'll say is there are different qualitative and quantitative factors that go into how we're credited. Getting the call is probably amongst the least important, and
Wow.
because of the nature of our work, where we're doing specialized services in the market. What's most important in many of these cases is the process of persuading the client to hire us, not to just do general legal work, to hire us to do sophisticated, high-end work that's often multi-jurisdictional. And that's a process that almost never happens from an initial phone call. And so while, it does have importance to obviously have relationships, because you don't get work if you don't have the relationships to begin with. it is necessary, and over the experience that Michael Kim and Steve Kobre have had, and that I personally experienced, really where the value is in terms of bringing in business is, getting the right team of people to persuade a client, a decision maker, referral source that not only are you the right firm to handle this, but you're doing something that no one else in the market is doing. You have a collection of lawyers in different geographies that are working together. You've developed this idea that is unique and that we haven't heard before from other firms. So that's really the ethos of Kobre and Kim. And I think that's one of the reasons I love working there, because when I think about when I am most satisfied, professionally as well as personally, it's in situations where I feel like I'm really working as a team, and I'm contributing, others are contributing in a way that the output is greater than the sum of its parts. It's really
Right.
it's a great feeling. And, it really requires you to constantly be checking your ego and making sure that your views about something, while important, that you need to sort of listen to others, know when to bring in others. Um, and that's, I think, a skill you develop. And it's an important skill, whether you're, I think, working in the model like Kobre and Kim or anywhere else, the ability to accept other perspectives, know that, even if you're a very experienced lawyer, um, you're naturally going to have blinders on. There's cognitive distortions. You have to continually be learning, particularly in this business. Um, and you need to continually be evolving. And that's really another aspect of the firm where knowledge, development, and innovation is really a key part of how we operate. We actually allocate specific time and credit to the lawyers, particularly the non-partner lawyers, and give them billable credit for work relating to these knowledge projects, for learning about different areas of law, different types of strategies, using certain strategies that are applicable maybe in one area of law and applying them in another area. So it's a very dynamic place to be. And as I said before, that is a big reason why I continue to really love what I do at the firm and continue to, have experience that I find very fulfilling.
Because if I'm looking at Kobre Kim from the outside, initially, I actually thought, you're one of the offshore law firms, right? Because you're sort of, fraud focused in the various jurisdictions where offshore is. But you're obviously onshore as well, because you're in the US, you're in the UK, key
Yeah.
markets, you're in other onshore jurisdictions like Hong Kong and, other places. So if you look at then the work that you're doing, is it tilted towards like more offshore work? Is it tilted towards more US work? Is it tilted towards more UK work? Or is it actually quite balanced?
I would say it's balanced. And the way I describe it is that we don't have a jurisdictional bias. And
So,
what that means is that we don't go out there and say we're looking for a case that will allow us to do work out of the British Virgin Islands. Um, it may be that when we get a case in, and I had a case a few years ago where we were representing uh, a US based private credit fund that uh, made a loan to a high net worth individual that split his time between Europe and New York. He owned a vineyard in California. The vineyard burned down. The loan went into default, and we were retained to enforce the personal guarantee that the high net worth individual had signed. When the case came to us, we initially thought that we'd do enforcement work in New York because the guarantor had submitted to New York jurisdiction through his guarantee. We knew he had assets there. We knew he spent time in Europe. But what we learned is that he held the very valuable, extremely valuable pieces of artwork, including the oldest Hebrew Bible that was still in existence. Very, very
Wow.
valuable property. And we learned that they were held through BVI trust. And that's something we only learn through a discovery process. And with that information, we brought in our BVI colleagues, and they petitioned to get, they successfully petitioned to get an interim receiver appointed to take control of this individual's holdings of the companies that own the valuable artwork. And that was the catalyst to reaching a settlement. So I think that's an example where, we don't map out ahead of time where we want the work to be done. We're obviously thinking about where the work will be sourced. And as I said before, in order to get the work, you need to have that initial connection. And so we're very active in all of our jurisdictions. In Asia, there's obviously a lot of Asia investment now into Latin America. A lot of Asia and Chinese investments are done through offshore companies. I think they're also go through Hong Kong. There's obviously a lot going on in Dubai right now. A lot of Russian expats have moved there after Russia started its war in Ukraine. And now, in the restructuring market, it's an exciting time because I'm sure you're seeing this sense that you always go to the US for a complex multinational restructuring has been questioned because now you have alternatives, real alternatives, including in your new home of
adopted home in the UK, the restructuring plans that we're trying to sort of get off the ground as an alternative to a Chapter 11, right?
That's right. And so I think it's an exciting time both to be a restructuring professional and to have a practice that is truly cross-border and doesn't have a jurisdictional bias or is jurisdictionally neutral, because while we don't handle general restructuring work, both myself and my colleagues, I think, speak a language that is beyond just we only know Chapter 11, or we're not used to navigating situations in other jurisdictions. Even though I'm based in New York, I am frequently getting my hands dirty with how restructurings work in the UK, or how you do a liquidation in Singapore, or the judicial reorganization laws of Brazil.
And do you think that it is, in your practice and in the firm that you're at, it's a benefit for you to be a US lawyer? Because of, I guess, the development of financial distress and that space in the US, because it is very court driven, and therefore you have that experience, and obviously because in a lot of ways, a lot of other jurisdictions have historically looked at the US for guidance. But obviously, everybody has been catching up in the meantime as well. Does it help you to be from the US, or is it sometimes also, not helpful because maybe prejudices that people have about US lawyers, other areas in the world, like, the Far East, or maybe, the Middle East, or Africa or South America? They may have prejudices against US, and therefore, it's almost a disadvantage to be a US lawyer. How does that sort of, because you have a very cross-border practice, and I can imagine that sometimes it helps and sometimes it hurts.
Yeah. So I would say it mainly helps. And I'd answer this in the first instance by my observation that you had this phenomenon of the exportation of Chapter 11 in many countries. And this is a phenomenon that's played out very recently. You have relatively new restructuring laws in Singapore, in the Dubai International Financial Center, certainly in the UK through Part 26A, that allows for US style restructurings that incorporate the cross class cram down feature that gives a lot more flexibility to get a plan or a scheme done than was the case under the prior uh, regime. And so I think from that perspective, it's incredibly helpful. But to your point, I if you approach international restructurings or insolvency from the pure perspective of a US lawyer, there can be a lot of downsides because while I think there's a lot of similarities to um, uh, US restructuring and insolvency law in other jurisdictions, ultimately, restructuring insolvency is about the culture and the community in which the proceedings happen. And so I feel that it requires um, sensibilities, you might want to call them soft skills, or an openness to consider different viewpoints, different ways of doing things. And that just makes me think of how fortunate I am to be part of INSOL and part of the INSOL Fellows program, which you're part of as well.
Absolutely. Yeah.
That, for those who aren't familiar with, INSOL International Fellows program, it's this intensive course, an LLM level course that I was fortunate to do about 10 years ago, where you learn about key cross border insolvency topics with a group that is selected of participants from all over the world. And it's very intensive, and you get to know the participants very well on a very deep level. And then when you finish the program successfully, you become an INSOL fellow. And now there's this big community of insolvency practitioners around the world that know, rely upon, and trust each other very well. And, that experience with the INSOL Fellows program in being able to communicate and often speak the same language. And when I say language, um, I'm not saying like that I can speak Singapore insolvency law. It means that there is a language, I think, of international cross-border insolvency that ties those who have made the investment and that are getting to know people, and less about substantive knowledge and more about a willingness to embrace things that are different.
Yeah, and as you said a number of times already, relationships are key. Professional relationships in that space, having respect no matter what role you play, and obviously having the knowledge, but the openness also to understand cultural differences. If you're looking back, early 2000 when you started and where we are now, and your initial sort of reluctance to be associated with bankruptcy, and now actually completely different, almost 180 degrees difference. You're almost, and I think rightfully so, you're proud to be part of the special sit space. What has changed? What are the big drivers that have made such a significant change in an area that obviously already exists for a long time, but has significantly changed in sort of our professional careers, more so than it ever did before?
Yeah. That's a great question. And the way I think about it is there's really two sides to it. There's way in which the um, professional market has changed and the way in which the capital markets have changed. And the two are very much connected, I think. When I started practicing at Brown Rudnick and doing bankruptcy, this was in, 2004, 2005-ish. You did have a pretty active secondary market of distressed investors that would buy up debt. But you did not at the time have the significant influence that private equity subsequently came to have over the restructuring processes. And it used to be the case that I think you could set up a distressed investment fund that would take minority positions in unsecured bonds, other levels of the debt structure, and you could ride the coattails of the bigger players, and you could make money that way. And that's changed dramatically, where I think in large part due to the influence of private equity, unless you are able to take on big positions and double down on your investment through dip financing, through a rights offering, or to be in the pole position to take advantage of a liability management transaction. If you're investing as a minority debt holder, you're at substantial risk of being diluted, even if you're within the same class of investors. And so I think that's one major shift that has changed dynamics significantly. Another one is that, when I started, you still had the money center banks that were doing the lending to distressed, troubled companies and providing debtor in possession financing. That, as we know, has changed dramatically, where you also have, large hedge funds, private equity funds that are in the business of, providing the rescue financing, providing the dip financing, bringing, I think, a level of sophistication to the process that is just a lot different than the traditional money center bank. And I think that's resulted in restructurings, running much different, certainly much faster than they did in the past. Because for most investors that are going to reap the benefits of restructuring, they realize how expensive the process is, number one. And number two, understand that by providing the financing to a restructuring process, you can exert control over the pace and in some cases, the results of restructuring.
And do you think that private equity has facilitated earlier intervention because, they have recognized that, if you deal with financial distress earlier, there's more opportunities than there was before, and that sort of, added to the professionalization of the space?
So, the way I think about it is that, with the advent of liability management transactions, where sophisticated investors, at the lender level, at the private equity ownership level, feel that they can try to accomplish a financial restructuring out of court, relying on what they perceive to be flexibility under the documents, that is often considered to be a much better outcome than going through a court process of a Chapter 11. Now, studies have been done that in many of these cases, liability management transactions actually don't rehabilitate the business and those companies need to go through Chapter 11 in any event.
So it's a delay.
Yeah. So I think there is this phenomenon where, the filings we see are often where a liability management transaction was attempted or may have been executed, but ultimately, you know, led to continued financial distress. And so you have uh, in the liability management space, there's a lot of restructuring lawyers that now call themselves liability management lawyers, or and there are departments at law firms that have been rebranded as liability management groups, and it's also created opportunities for firms like ours to get involved in situations where the minority or excluded lenders bring suit to challenge the transaction, and we've been involved on all sides of that litigation. For sponsors, for the majority lenders doing the deal, the minority lenders that were excluded. And there are constantly conflicts, both legal and business conflicts, that come up for the full service firms, because given that capital to distressed companies is now coming from a wide range of private equity funds and hedge funds, it's frequently the case that a large full service law firm will have important client relationships on the other side of these deals. And
Yeah,
so,
but
yeah,
it blurs the lines, doesn't it, between what you initially sort of defined as we're doing litigious litigation work, not transactional work. But if we're doing liability management, that is transactional, but actually against a potential background of litigation where that skill set is needed as well. And especially as we were saying about special sits, you need to have both in order to get to the result. So does that also then in your firm and your offering sort of you need to be flexible as well? You can't be too strict on your only litigation, because if it is transactional but with a potential sort of
so,
litigious aspect to it, you can still do it.
yeah. So to be clear, most of the work we do in the liability management space is where there's a dispute that's uh, led to litigation or is about to lead to litigation. Um, so
It was my understanding, Dan, that you also do actually almost helping avoid litigation by just, maybe helping an independent director to sort of, know what the pitfalls are if you go
yes,
through the process. And therefore, if you're well informed, you make the right decisions.
yeah,
Maybe the likelihood of litigation is a lot less. And if it happens, the chances of success are higher.
yeah, no, that's absolutely right. As part of our special committee practice, we've done a few cases where we've advised, the special committees on, you know, entering into the liability management transaction. We won't do the deal itself, I guess is
Yeah.
what I'm saying, but certainly our perspective, having litigated these cases on all sides, has sort of given us the benefit of being able to give advice that is practical and based on, the experiences that we've been through in this space.
Yeah. So one thing I want to sort of maybe explore a little bit as well. You were saying that actually there are, not only lawyers, but also, people that assist the lawyers. And I guess, one of the assistants of lawyers that everybody's talking about is AI, right? That's going to change our space. And it's going to, make the existing lawyers a lot more productive. They have more tools in the toolbox to do what they need to do. Uh, um, how do you think that, and obviously also the kind of insolvencies that we have, with cryptocurrencies and, digital assets as well. It's a whole new space that opens. And it's my understanding you guys are right in the middle of that.
Yeah. So I think that, as with any new development, whether it's in the law or technology or otherwise, you got to stay current with the times. So my own personal view is that AI is not this like, inflection point in the world where suddenly, all these people are going to be out of jobs and what
Lawyers
we've
are obsolete,
it,
doctors are obsolete. It's all going to be, the AI that basically gives the legal advice and the medical advice.
yeah, I think it's going to be incredibly effective as a tool, one tool in the toolkit to do things in a much faster and perhaps efficient way. Um, don't think particularly in the restructuring business. We're anywhere close to being at risk of AI taking over everything. Because if you think about it, and we touched on this before, restructurings, whether they're cross-border or domestic, involve real human beings, a lot of personalities, the investors making the investment decisions, the directors who sit on the boards, the lawyers who do the work, the judges who are deciding these cases. There's a lot of human interaction, negotiation, back and forth. So I think that is going to continue. Um, on the other hand, I think that um, if you ignore the technology, you do it at your peril, because I've just seen firsthand at the firm the way in which we can produce certain documents in a way that is allowing us to operate at greater speed and to do things in a way that we haven't done. You had mentioned crypto, and I'm not sure this is purely AI, but with a lot of the work we've done in asset tracing and crypto, we've had to rely on um, software, for example, that would allow us to map out where the flow of crypto has gone through the different wallets and exchanges and whatnot. And we invested in that, um, software some time ago. It's the same program that the U.S. government uses when it's doing its own asset recovery and tracing. And we have, as part of our analyst program, we have these specialists that it's really their job to, you know, help the firm innovate, whether it's developing AI tools or becoming a certified fraud examiner, learning how to tap into databases to learn information on targets or people that we want to know more about. So that's my general perspective of AI and how it can be a benefit, but also that it's not at risk of rendering us obsolete. That being said, um, you know, from the perspective of a younger lawyer, I think we all need to be careful and thoughtful about how we're training the younger generation. Because when I think back to what made me who I am and how I learned, it was face to face. It was me sitting in Ed Weisfelder's office, with him on the phone with Carl Icahn chain smoking.
Yep.
Literally. And that was something that, you just it can't be replicated through online platforms, through Zooms, through AI learning. That's my view.
Yeah. And another concern I'm having is the speed you were saying, right? I mean, if you look at when we started and where we are now, things are going so much faster with technology. But can it even go faster than that? And in our space in particular, where time is limited and of the essence, and there's time pressure all the time, how do you deal with that? Because it's not a sort of 9 to 5 job, but it cannot be 24/7 all the time as well, because again, we're humans, right? And there is something also outside of the professional life, or there at least should be,
Yeah.
right? How do you deal with that, and how do you think that going forward, we're going to be able to deal with that?
Yeah. Well, I think there are pros and cons to the advent of technology and AI. I'd say the pros are that, the technology is developing in a way that the stuff that is monotonous or that's a drag on our time and does not necessarily reflect true value that we provide as lawyers professionals can be handled by something or someone else, something. um, and the cons are that, there is constant stimulus. And, uh, as a professional in a world in which, everyone has access to technology 24/7, you're working in an environment such as, myself at the firm, that's a cross-border practice and with clients in Asia, things are coming in literally around the clock. How do you
Yeah.
deal with it? And I feel that those who are most successful um, in this business and adapting to those circumstances have a knack for understanding what's truly important and what can be left to the side. And I think that only comes through experience and the judgment that you develop through experience. But it is a challenge, um, and something I think about a lot. And you know, I, different folks have developed different strategies for how to manage that. I think some of my colleagues, they will block out time in their calendar and just call it quiet or study time or focus time. And they'll sort of tell people they're offline for an hour or two because, at the end of the day, notwithstanding the demand for speed, clients want our judgment in
Yeah.
difficult circumstances. That's what they're ultimately paying for. Making decisions, advising them on the right decisions in a very complicated set of facts.
Yeah. The question doesn't become easier because it's sent to you by email as opposed to by letter, right?
Yeah.
It's the same thing. And we still need to, obviously, maybe you have more tools to research quicker, but still you need to make a call on things. Um, so if you look at the practice, special sit space, what do you think are, some of the characteristics that you need to have in order to, I guess, have longevity in the space?
Yeah. That's another great question. I think we've already touched on this. There is tremendous innovation in restructuring in particular. Obviously, we talked about the tech aspect of it, but there's a whole nother aspect of this in that both the law, the market, the professionals, it's always changing. There's always something new, a new way to do something. There's, you know, we talked about before that, US listed companies are now considering through their restructuring advisors whether it's better to re-domicile in the UK to do a proceeding there as opposed to filing for Chapter 11. And so I think being of the mindset that you need to continue to learn, you need to continue to speak to people, you need to continue to sort of accept that you're not going to know everything, but you have the drive and the willingness to learn what you need to learn, that you know who to reach out to when you don't, and that you're flexible in terms of operating in new areas that you may not have practiced in the past. Um,
Yeah. So if you're looking for certainty and predictability, that's maybe not the space you want to be in.
No, I think that's absolutely right. I had a good friend in the field when I saw in London recently at the INSOL International Conference, and he said to me that he thought those who do well and are attracted to restructuring in special situations are those that like working in chaos. They're comfortable working in chaos, um, and that really resonated with me. Um,
Yeah.
and
And it gives you a buzz, right? I mean, it's almost going back to the beginning of our conversation. Maybe if you go and visit Boston, you get a certain vibe. If you visit London or New York, you'll get a different vibe, right? And maybe that vibe sort of translates maybe in a certain way to the practice area, right? There's a lot more going on, and if you think that's overwhelming, then maybe it's not the space to be in. But if actually that is something that fuels you, maybe that's exactly the space you need to be in.
Yeah. And then there's also this sense, and I mean, I think it's applicable in a lot of areas of law and practice, but um, obviously what makes restructuring tick is the creativity, the ingenuity of the lawyers that are operating in the space. You could read the US bankruptcy code cover to cover every night for a year, but coming out of that experience, you still wouldn't know how to, work in the space and work in the space
No.
effectively. And so it's like using the left and the right part of your brain, the creative part that is thinking about stretching boundaries and willing to test things. And, obviously the other side of the brain that needs to be focused on the details and understanding very complex credit documents and legal doctrines, and sort of the ability to modulate between the two, whether you're a professional or an investor, I think is just, it's important. I think it comes from experience, but also you need to embrace that.
Yeah.
You need to do it with purpose, because it's very easy to settle into a practice and say, I'm going to learn X and do X, and I, you know, I don't do Y. I don't know about it, so I can't touch
Yeah. And again, I think the cross-border element to it also relates to the fact that financial distress and how you deal with it is very culturally motivated. And, there's so many different cultures. And therefore, people have tried, but unsuccessfully so, to get like uniform insolvency laws, right? We can't get to, because exactly for that reason. Okay, there is a model law on the procedural side, but again, not universally applied. And even if adopt the model law, if you adopt it in the US and you adopt it in the UK, you would think it's going to be the same, but it's not. There's still different interpretations. So it requires people indeed to be, light on their feet and to be flexible and to be, you know, finding solutions to problems, as opposed to, there's one way of doing it and I'll just, repeat doing that. That's just not going to work, not in a cross-border insolvency situation. And I guess, you either like that or you don't. But that's really, for me, what is very attractive is indeed the fact that you're dealing with all these different people, all these different cultures. It is universal because financial distress is not just one country, but how you deal with it, and how you can deal with it, is different. But you
it.
can't apply necessarily everything that we have in the US in Thailand, for example. But you can have a conversation about it and make people locally aware of many more ways of addressing the same problem. And to me, that's very exciting.
Yeah, no, absolutely.
And what do you think, if you then look at what success is in the special seed space? How would you define that for yourself?
Um, so when I think about success, I really tie that to whether checking in with myself periodically. I feel like I'm continuing to do things that stretch me, um, that continue to force me to innovate personally, professionally, and continue to help build something. And that is something we haven't directly touched on, but I get a lot of professional satisfaction from, frankly, helping to grow something at the firm. And that was, separate from the substantive draw of coming to Kobre and Kim, it is a platform that I think has enabled me to help build up what I'll call a bankruptcy offering, but within the very clear, firm platform of international disputes of investigations. And so, sort of helping to grow other lawyers into the type of lawyers that know this stuff, meaning bankruptcy, insolvency, but know it in a way that they can apply it in the unique way in which we handle our cases. And, have an influence on them is, to me, very professionally rewarding. And yeah,
What about outside of the profession? Do you have like ambitions outside of the profession, and are you actually able to, find enough time to do them? How do you sort of, balance those two?
I wish I could say that, I had the perfect answer to that. I told you, I think before, that I'm really into music. So I guess my ambitions of being a rock star have gone by the wayside. So we'll have to rule that out. But I do still play guitar a fair bit. And I find that's a sort of a calming outlet for me, to have that by my side. I have a family, a small family, my wife and 12-year-old daughter. And we actually do a lot of skiing. And our daughter does competitive ski racing in upstate New York. So the last couple years, we've been going up to this mountain almost every weekend. And
Wow.
I think skiing is it's a great outlet. It's great to be in nature. And I tell people that it's almost like the perfect thing to do as a lawyer that has incredible demands, because you can like go down the mountain and have your freedom and exposure to nature. But then if you have something happening, you can get on the lift or the gondola, take out your phone and
Just deal with it.
yeah, deal with the email or maybe do a quick call, and then you go, back on the slopes again. Um,
And how would you explain to your daughter what you're doing?
it's interesting. So I'm a lawyer, my wife's a lawyer too. And Um, she had this vision because she was growing up, in COVID, where she saw us both working from home a lot. And her view of being a lawyer was that it was something really boring, that you have people that, are just sitting in front of their computers, constantly on calls, working on very long documents, and that it was, nothing she would ever want to do. As she gets a little bit older, I've explained to her sort of what I do in a way that I try to have resonate with her. Just as a sort of side note story, I was involved in a recent case that I think where she understood, um, how impactful law can be. Um, uh, this is a recent case where I was representing um, a Russian expat, um, Alexander Zhelezniak, who ran one of the biggest banks in Russia. And he became aligned with the political opposition in Russia. And after that, a series of events happened that were very adverse to him, where his bank was put into liquidation. Personal bankruptcy cases were filed against him. He was accused falsely of embezzlement, and he left Russia, essentially fled to the United States. And it's a big deal for him and his family. They received lots of threats, including death threats from
Wow.
folks back in Russia. And recently, the Russian bankruptcy trustee um, came to where he lived in the state of Massachusetts and filed a Chapter 15 bankruptcy to have his case recognized in Russia. And I got involved, and we prevailed in defeating recognition.
Wow. Because
Um,
that's not, the
it-
whole idea is that you should be, and only in exceptional case, you should not be granting recognition, right? So
yeah,
that's that's very exceptional.
yeah. So it was a very gratifying for me, and it meant a lot to me because it had such personal, um, such a personal issue for the client and his family that you don't always see. But when I was explaining the case to my daughter, I think she finally began to understand that, all right, this can be a very rewarding and impactful field. I don't know if she's going to go into law. Um, I'm certainly not pushing her. She's,
There's various ways. Law is just one avenue, right? There's
yeah,
various
right.
ways of getting into the special sit space if that's what you want. We've both done law, but you could get there in many other ways, it seems,
Yeah.
as well.
Yeah.
So your case about the Russian expat sort of reminds me about the huge impact of sanctions in across the world, in our space as well, and then geopolitics, and the impact it has on professions as well, our profession, but obviously professions of
Yeah.
clients that sort of are affected, and all of a sudden you're in financial distress as a consequence of that. uh, What's your take on that? Is this, an exceptional time, but also this will pass, and or is this, the new normal, and we all need to sort of adjust to, this huge uncertainty on top of the existing uncertainty that naturally is in our space?
Yeah. That's a great question. What first comes to mind is Russia's war against Ukraine is very personal to me because my wife is Ukrainian.
Oh,
Um,
wow.
so, she, and we know a lot of people who have been affected by the war. Um, um, and, but separating that for the moment, um, it um, I think we are in this new reality, where the role of the United States, in relative to the world order has changed, dramatically. Not sure if it's, I would say it's irrevocable, sort of the
Mm.
change in the world order, but I think it's, resulted in situations where, um, unpredictability in terms of the role of state governments, um, in the affairs of private industry is something that everyone's going to need to take into effect. Um, Now, for professionals, there are opportunities. Um, for our firm, I had mentioned we have a Dubai office, and a lot of the Russian expats that wanted to leave Russia went there, and we've done work for some of them, and sort of navigating issues about how one protects assets, how one manages their global businesses in the face of sanctions or even tariff wars is something that I think will continue to um, be something, to give thought to. I mean, I'm cautiously optimistic because with everything going on in the world right now, in Iran, the Middle East, with Israel and Russia, Ukraine, the U.S. markets have been amazingly resilient. And I don't know if that means, you know, we're setting up to have another bubble that bursts, but
Well,
I
that's been predicted for years now, right? That the bubble
yeah,
is going to
and
burst, but it hasn't yet.
it hasn't. And I can't tell you how many times, people have said, "Oh, this is the year, this is the year." I think the reality is that, the financial crisis of 2008 was a once in a century event. And
Mm.
so I don't think we'll ever see anything compared to what happened there, where the credit markets were completely frozen. So, um, I think, with the sort of transformation of the capital markets and the way in which investors have become a lot more sophisticated, and the way in which there's just a lot more capital that's being put to work in situations to allow, I think, industries to weather the storm. Um, and, through government policies that, we're in a space where, there could be trouble ahead, but I'm just not sure that we're going to have this doomsday scenario that some people have predicted. I mean, a lot of people are talking about private credit now and whether there's a bubble forming there. Um, and people have their views about that.
What about, because if you look like globally to our space, you know, you have obviously the centers in New York and London, you have the developments in Europe, you have the developments in the Far East, in South America, and in Africa. But what is the single, you know, biggest thing to develop, I guess, a special sit space in a jurisdiction? Do you think it's legislation? Do you think it is change of mentality towards financial distress? Do you think it is, you know, professionalization of practitioners? Do you think it is, you know, judges? You know, what in your experience
Yeah,
is, you know, or is it the secondary market? But okay, how do you get a secondary market? Where do you start? Is it the World Bank that needs to focus on things?
yeah. Well, I think it's some combination of everything you've said, but I think you got to start with rule of law because when I'm and when my colleagues are speaking to investors, where we may have a judgment that of a client and the client wants to potentially monetize it by selling it, and we're speaking with folks who are wondering how do you go about enforcing the judgment in jurisdictions that are unfamiliar. That's the first thing they're focused on. Is there a credible rule of law? And by rule of law, I mean, obviously, you start with the legislation, but that is obviously just the starting point. You need to have a judiciary that, um, is willing to apply the law, apply it fairly, apply it predictably, and um, reach decisions that don't take years and years. That's something that has been an issue in other jurisdictions where they have great laws on the books. They have good judges, but because of backlogs or because of just the perhaps judicial culture, it is difficult to get momentum via court decisions. And then obviously having a culture of lawyers that know how to advance the space is critical as well. Um, I'm thinking of the Brazil market. I've gotten to know a lot of folks in the Sao Paulo restructuring community. They are all terrific. They're smart. They have a close knit group, and I think they've done a lot to advance, um, you know, the restructuring regime. And I think it's paid off because you're starting to see a lot of judicial restructurings happening in Brazil that may have otherwise been filed under Chapter 11. To be clear, it's still the case that a lot of um, cases coming out of Latin America, including Brazil, get filed through Chapter 11. But I have seen a shift. Um,
So you see again, you know, going back to the point that we've made a couple of times, that it's relationships, it's you know, people with the same, I guess, you know, mindset, in the same space with the same drive, you know, even though the circumstances may not be ideal. But if you get that momentum, you can make a change, even if all the ingredients are not there, you know. A coordinated group of like-minded, you know, professionals can make a difference.
yeah, absolutely. I mean, one of the projects that we've talked about within INSOL focus group is having a group of the INSOL fellows meet with judges from the different jurisdictions. Frankly, to also meet with judges in the United States who
Yep.
actually don't regularly hear Chapter 15 cases because, as when you're filing a Chapter 15 case, frequently you're thinking you file in either New York, Delaware, perhaps Texas. But many of the bankruptcy judges, they're extremely smart, sophisticated, but they don't have experience with cross-border cases. So that's one of the projects that we've talked about within a particular INSOL focus group that I'm involved in.
Yeah. So you were saying about your daughter being focused and competitive on in skiing. Do you think that in our space of special sits, you need to be competitive?
Um, I do, but I think you need to be clear on how you define sort of competition, because going back to what I said, I don't think there's any substitute for the ability to work very well with others, both internally within the firm and externally with either co-counsel, with the investment bankers, even opposing counsel. So um, I think to me, being aggressive means being driven to get to a certain result, but not to, show everyone you're the smartest person in the room.
Yeah,
And not,
it's almost like your comparison with your early experience with music in the band. You know,
yeah,
you need to have passion for what you're doing, right? And is that competitiveness? No, it's passion for what you're doing. And you need it in special sits as well.
yeah, no, I definitely agree with that. And even on the investment side, I mean, special sits investments, the way I think about it is it's almost always going to involve some type of a human process, maybe a court process, a negotiation process, but it's almost never a passive investment. And so, you could be the most brilliant financial whiz and have mapped out probabilities for how something's going to play out. But if you're not um, someone that is willing to sort of make that connection with others, whether you're on the investment side or on the professional side, then it, may not lead to the optimal result or optimal return on investment.
Yeah, that's right. So we've covered quite a bit. And, last question I usually ask people is, especially for the younger folks listening and watching this, if they are considering, venturing into the special sit space, be it as a lawyer or as a, financial, a banker, or maybe even through business, um, what would be your recommendation to them?
Yeah. So my recommendation first and foremost is to talk to people. Um, I recently saw a clip of Steve Jobs saying that what he thought distinguished those who did really well with those who sort of were stagnant were that those who did really well weren't afraid to reach out to people to ask them questions, to ask them for their time. And so I am always willing to meet with people and speak with them if they show an interest in what I'm doing, because I feel like I have an interest in seeing people continue to drive the profession. And as I said before, I get gratification from seeing, others who are passionate about the field. Um, so that's, in part how I'd answer that question. Um,
Well, go ahead.
yeah. And then, particularly now in this era of technology, it's important to get behind or, turn off your computer and get out there. And, again, I said meet people, but it's experiencing things, going to a conference, maybe going to a court hearing. You may not have a role in the court hearing, but just observe how it's done. And I also think it's important to know what's going on generally in the world. So I try and read the Wall Street Journal fairly regularly. I love reading The Economist. For me, that's like one-stop shopping for what's happening in the world, what's happening in the markets. It's very insightful. And it's actually what I look forward to. If I can get like one quiet night a week where I can sit down, have a cup of tea, and read The Economist, that is like,
But it opens up, I guess, sort of another big debate that is ongoing, right? Is a traditional media sort of not actually, telling you how it is? What is fake news? What is propaganda? What is the narrative that people, if you go to the traditional things, get? It's very difficult to identify, what exactly is going on in the world, because it depends on to whom you're listening, right? And a lot of, I guess, still media is focused on always focusing on the bad things, never really on the good things. I mean, very recently with, I guess, the hot days that we've had in the UK and in the Netherlands and in Europe generally, maybe 20 years ago, we would report it as absolutely great. Finally, some, really nice summer days. Now we're getting, everybody needs to be very careful, is going to get very hot. You need to just do this precaution, that precaution. People are scared to death. My mom is scared to death about, there's another sort of heat wave coming. It is a little bit a sign of the time that, we're looking at things, not necessarily, in my view, in the right way. And
Yeah.
I sometimes actually want to shut off and just look at things my way and try to do it more positively as opposed to negatively. So I
Yeah.
take your point there, but sometimes that's not so easy
Yeah.
to
No.
figure out where I need to get my information.
Yeah. I don't watch the nightly news. I don't watch CNN or Fox or any of those stations. I just feel that I'm not getting good information, and many times I think, to your point, it just makes me feel bad. And
Yep.
so I do try and be resourceful with what I read, and obviously I don't have that much time, but just to riff on what you just said, that I think has some significance to our world. For a long time, um, particularly post COVID, I was hearing that the city of Hong Kong was in decline, that all of these foreigners were leaving, that due to the influence of mainland China, the culture of Hong Kong had changed in a very bad way. When I visited Hong Kong for the first time, um, years ago, I had the complete opposite experience. It was incredibly vibrant. Um, there were many professionals there. There was a lot going on. And then I went back again and it was even more vibrant. And, if you had just read sort of the news about what's happening in Hong Kong, you would have the sense that, it's doom and despair there.
I had exactly the same, especially with Hong Kong as well. And you speak with locals, professionals there, and they tell you none of this. But again, if you just only had the headlines, that is exactly the sense you get. I think one other thing maybe to explore is how important is it, for you, what others think about you? Because obviously, with social media for what it
Yeah.
is, right? It is very easy for, I guess, the next generation, our kids, to sort of, believe that the lives of everybody else is so much better than your life
Yeah.
because they're doing all these wonderful things and you don't. Uh, um, and I guess, how do you deal with that, right? Obviously, it's important what other people think about you, but only people that you actually, genuinely value their opinion, not just everybody. But it stifles people, I think, in maybe making decisions. And sometimes, especially I think in our space,
Yeah.
you need to be contrarian, right? You need to
Yeah.
sometimes do things differently from everybody else. If you always follow what the others do, you're you're not going to do well in this space. So you need to also be mentally strong enough to sometimes hold your ground, even though a lot of people will say, "Oh no, don't do that," because again, people are afraid of uncertainty,
Yeah.
unpredictability. But if you believe in it, just have a go, especially if you're young.
Yeah, that's such a great point and a great, I think, piece of advice to the younger generation or to anyone. And it's something that I only truly learned and internalized, I think, recently, which is that if you're being true to yourself, doing what you think is right, there are always going to be naysayers, people who
Mm.
resent you or don't like you or think you're doing something wrong. And if you are constantly of the view that you need to do something to please everyone, or that's accepted by everyone, that's a way in which you get paralyzed. and are unable to grow and progress. And I think a lot about what's happening with social media with the younger generation, particularly since I have a 12-year-old daughter, about how there is this sense that you have to go with the crowd, or you need to be popular. You need to get a certain amount of likes with your post. And um, it does give me concern. And I am hopeful that, there is, a message that is told and reinforced by folks to just tell people starting either in this business or in any business that you just need to be thick-skinned as best as you can, and B, accept that people are going to say things and do things that um, you think reflect negatively on you, but you shouldn't let it phase you from doing what you think is right, and growing and getting new experience.
I couldn't agree with you more. And again, maybe sort of last comment, it ties into our practice area tremendously, is there is no failure, right? There's just failure to try your
Yeah.
best, right? That really is the only failure there is. So anything that doesn't work out the way you had set out of it, well, look, if you learn a lesson from it, you take it with you to the next thing. And anything that is successful, it's never linear, right? People have always tried other things before, but you don't see that. You only see the end result when they've made it, but not all the hard things that, came before. So again, don't be discouraged of, not achieving things immediately. And in our space, I guess, financial distress, you need to have a second chance, right? It can't be that just because, one business failed for whatever reason, you're doomed forever. You should have learned from this. And if you're not a fraudster, but you've done, what needs to be done, then you should have a second chance to try again. And, that is, I think, in our space, very important. That's why it shouldn't be a taboo to talk about financial distress. You should do it as early as possible, because then you and I can actually do something about it, right?
Yeah, that's sage words.
Excellent. Well, thank you very much, Stan, for your time. I thought it was a great conversation to have, and hope that we can, have many more of those conversations in the future.
Absolutely. Thank you for having me, Peter. I really enjoyed the discussion too.
Excellent.